Good morning and welcome to the July 31st, 2024 meeting of the Texas Commission on Environmental Quality. It is 9:38 a.m. I'm Commissioner Bobby Janeka and I'm joined by my colleague, Commissioner Katarina Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you would like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tcq.texas.gov with your name, affiliation, and the item that you would like to comment on. We will do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking. And please check to make sure that your line is unmuted before proceeding. Ms. Smith, please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Highland Lake Midlothian 1 LLC for new TPDS permit number WQ00159999001. And the order of presentation will be the applicant, followed by protestants, the ED, and then OPIC. Each party will have 5 minutes for oral argument, but the applicant may save time for rebuttal as it bears burden of proof on the application. So we'll begin with the applicant. I believe we have Ms. Helen Gilbert.
Good morning, Commissioners, General Counsel. I'm Helen Gilbert. This morning here on behalf of applicant Highland Lakes Midlothian 1 LLC, we support Judge Shenoy's proposal for decision and request that you issue the permit as drafted without changes. The ALJ did a very good job tackling the technical issues in this case, and we believe there's no basis for you to change the proposed order except for the 2 non-substantive typographical errors noted by the ED and suggested in the ALJ's letter. This case is really the 3rd act in a 3-act play, if you will. The first 2 acts were Ellis County, Waxahachie, and Midlothian's protest of the 2 municipal utility districts that the applicant created for this development. And now the 3rd act is the TPDS permit that would make utility service to that development a reality after many, many years of planning. In the MUD protests, the county and the cities promised that there would be an unreasonable effect on water quality, particularly nutrients. So we got to the contested case hearing, and despite all that lead up, that's not what was delivered. The protestants' 1 expert spent 1 day at the site collecting 1 set of data points and argued that that data should replace the executive director's tried and true Qualtex model incorporating default coefficients. The PFD correctly found that this was inappropriate. 1 set of data was very questionable. It lacked QA/QC. It conflicted with your implementation procedures. Methods were flawed, and substituting dry creek measurements for a model based on flowing water is just incorrect. And the PFD discerned that all correctly. Late in the process, the protestants also raised or resurrected their claim that a combined NORI and NAPD notice was improper. Your rules 39.405D clearly allow for that, and that's a common practice of the commission. Nobody was deprived notice or due process by the combined notice. Finally, on the issue of forever chemicals or constituents of emerging concerns, the PFD again was right there that there are currently no rules regulating CECs, and therefore there's no basis to rebut the prima facie case and presumption that the draft permit meets all applicable state and federal rules. Since there was no credible evidence in the record on CECs, even what constituents they were, how they may degrade, how they may impact, there's just no basis for protestants' claim that the applicant should be required to sample them. That would make very little sense and constitute ad hoc rulemaking. I'd like to reserve the balance of my time for rebuttal unless you have any questions now.
Thank you. We have no questions this time. We now call on
Assistant Attorney, Ms. Emily Rogers.
Good morning, Commissioners and General Counsel. For the record, I'm Emily Rogers, and I represent Ellis County and the cities of Waxahachie and Midlothian. The county and the cities disagree with the ALJ's PFD and recommendation to grant the wastewater discharge permit in this case. This area of Texas, particularly Ellis County, is experiencing unprecedented growth. It is more important than ever that these non-regional wastewater discharge permits that are issued development by development meet the highest standard to protect the natural resources in the area. In this case, site-specific evidence showed the default modeling parameters were inaccurate and likely didn't represent the worst-case scenario. The protestant's expert visited the site, made key observations and measurements that showed that the modeling inputs were not representative of the stream on site. The model used a deeper and slower stream than what exists in reality. In the end result is that the model predicts a dissolved oxygen concentration that will be too low to meet the water quality standards. Failure to get the permitted parameters correct will lead to violations of water quality standards in the future. This will only be exacerbated as development continues in the area. The counties and the cities address the other issues regarding the denial of the permits in the closing arguments and exceptions to the PFD and won't repeat those here. For the reasons we've stated therein and addressed today, the county and the cities request that the permit applications be denied. I'm available for any questions. Thank you.
Thank you. We have no questions.
We have the ED.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. I'm Aubrey Pawelka, representing the Executive Director. With me today is Alfonso Martinez with the Water Quality Division. Regarding the 5 agreed issues, the Executive Director supports the administrative law judge's conclusions for all 5 issues. The ALJ found that the draft permit is protective of water quality in accordance with applicable Texas water quality standards, that the application was properly noticed, and that a permit, if issued consistent with the draft permit, would be protective of human health and safety, the environment, and physical property. Therefore, in the absence of evidence that the draft permit violates a specifically applicable state or federal requirement, the ALJ recommended that the Commission issue the draft permit and adopt all findings of facts and conclusions of law contained in the proposed order. The Executive Director respectfully recommends that the Commission adopt the ALJ's findings of fact and conclusions of law with the corrections as noted in the ED's exceptions to the PFD, grant the application, and issue the draft permit without changes. Thank you, and we are available for questions.
Thank you. I see no questions.
OPIC.
Good morning, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jennifer Jameson on behalf of OPIC. OPIC respectfully recommends issuance of this permit as outlined by the ALJ's proposal for decision and as amended by the exceptions letter. OPIC would point out that it agrees with the ALJ, the ED, and applicant's contention that the ED's modeling properly does not include an on-channel impoundment in Reach 1. In this case, because there was documented heavy rainfall a week prior to Mr. Osting's site visit, which accounted for the presence of water at the location. There's no credible evidence that the pool was persistent. And finally, the ED's review of the Google Earth data confirms that the pool is visible in imagery on only one other date over 5 years prior to the site visit. With respect to dissolved oxygen, OPIC agrees with the ALJ's conclusion that protestants' 2 measurements represent snapshots at a given moment, not the 24 average DO measurements that the IPs prioritize. Further, given that the ED's models already assume the worst case scenario with respect to temperature and the fact that the models are made more conservative by omitting extra oxygen that might be added by algae photosynthesis, OPIC is satisfied that the ED properly used a default DO saturation of 80% to model expected 24-hour average DO levels. With respect to phosphorus, OPIC agrees with the ALJ's conclusion that protestants supporting evidence on the issue. A single phosphorus reading was not shown to violate any applicable standard or requirement. Accordingly, OPIC cannot find that this evidence meets protestants' burden of production to show that one or more provisions of the draft permit violate a specifically applicable state or federal requirement. As such, OPIC recommends that the Commission adopt the proposed order and issue the draft permit as written and amended by the exceptions letter. Thank you, and I'm available for questions.
Thank you. I see no questions.
And Ms. Gilbert, you have 1.5 minutes remaining.
Thank you. Just a couple points. I'm glad that Council for Protestants pointed out the level of treatment. In the final phase, it will be a 5510.5. It's a basically tertiary treatment is the highest level of treatment available. Waxahachie, by contrast, has no phosphorus limit at all at a much higher volume. There's been a lot of discussion of what constitutes site-specific data. Site-specific data, in order to properly substitute data for the default coefficients in the model, has to be robust, systemic. There's got to be a lot of it. It's got to be taken at multiple locations over a lengthy period of time, not on one day, and cherry-picked. And as OPIC said, a snapshot in time that really is inconsistent with your IPs and other standards. Again, remember the level for rebuttal evidence in statute 2003.047 I2 is that they must demonstrate a violation of applicable rules, and protestants simply didn't demonstrate that. And I'm happy for any questions you might have.
Thank you. I see no questions. Well, Commissioner Gonzalez, in this matter, the administrative law judge determined that the applicant met its burden of proof on all 5 issues and recommended that the draft permit be issued. After reviewing the record, I agree with ALJ's conclusion that the protestants did not present any evidence to rebut the prima facie demonstration established by the administrative record. Accordingly, I believe the evidence supports the ALJ's determination and recommend the Commission adopt the ALJ's proposed order and issue the TPDS permit, but with some modifications. One of the 5 issues litigated related to the discharge of emerging contaminants in the effluent. This was an issue that applicant and protestants agreed to when the case was directly referred to SOA, but it's an issue that the Commission routinely declines to refer because it is not relevant or material to our decision. Contaminants of emerging concern, or CECs, are not currently regulated by the EPA or TCQ in the TPDES permitting program. Therefore, I propose deleting finding of fact 87 because the Commission does not regulate CECs in the TPDES program as a matter of law and does not evaluate CECs in permit applications. I would also delete conclusion of law 10 and replace it with language that there is no federal or state law that regulates CECs, and that issue 5 is not a relevant and material issue for the Commission to determine in this matter. Finally, I also note that the 2 minor exceptions requested by the ED and accepted by the ALJ appear appropriate for clarification purposes, so I would also adopt those changes to the ALJ's original proposed order. What are your thoughts?
I'm in agreement.
I will move that we adopt the administrative law judge's proposed order with the revisions recommended in the ALJ's reply to exceptions letter dated May 1st, 2024, and add, quote, and the permit shall be issued, end quote, to the end of ordering provision 1 for clarification. Also add, delete finding of fact 87 because the Commission does not regulate CECs in the TPDES program as a matter of law and does not evaluate CECs in permit applications. Issue 5 of the PFD, and order is therefore not relevant material to the Commission's decision and is not an issue that the Commission would refer to SOA for further determination. And for the same reasons, delete conclusion of law 10 and replace it with, quote, no federal or state law regulates CECs in TPDES permits, and therefore issue 5 is not a relevant and material issue for the Commission to determine, end quote. I further move that we issue new Texas Pollutant Discharge Elimination System permit number WQ0015 999001 to Highland Lakes Midlothian 1 LLC, and we adopt the ED's response to comments.
A second.
The motion is made and seconded. All those in favor say aye.
Aye.
Aye. Motion is passed. Ms. Smith, call the next matter.
Item 2 is the consideration of the application by Bioside Partners Santa Fe LTD for new TIPD's permit number WQ00159440001. And as a housekeeping matter, the applicant filed very late last night or very early this morning a motion to remand this matter as they are withdrawing their petition or their application. And so I'd recommend that the commission address this motion first.
Let's first take up the motion to remand. And because the motion was just filed, I would like to give the executive director and the Office of Public Interest Counsel an opportunity to respond to the motion now. So executive director, staff, do you have any objection or response?
The ED has no objection.
And Public Interest Counsel, any objection or response?
We have no objection as well.
Thank you. We also have several of the requesters present virtually today with us in the meeting. I believe we've shared those names to be unmuted, but I will request if any of you are participating, Emily Harmon, Melissa Jared, Robert Martinez, Roger McCrary, or Dana Salter, do any of you object to the motion to remand the application? Please say so at this time. Moving on, Commissioner Gonzalez, in light of the applicant's request to withdraw its application, personally, I would grant that motion to remand the matter to the executive director in order to process the withdrawal of the application. What are your thoughts?
I agree. Do you want me to make a motion?
Thank you.
I move that we grant the applicant's motion to remand this matter to the executive director.
I second the motion. The motion has been made and seconded. All those in favor?
Aye.
Aye. Motion passes. Ms. Smith, please call the next item.
Item number 3 is the consideration of the petition filed by Lund Farm Investment LLC for the creation of Lund Farm Municipal Utility District. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Before us, we have a petition for the creation of Lund Farm Municipal Utility District with a request for additional road powers. On this petition, we have hearing requests that were submitted by John Carlson on behalf of himself and his mother, Marjorie Carlson, from Gary Johnson on behalf of himself, his wife, Barbara Johnson, and son, Terry Johnson, and from Mitchell Schrader on behalf of himself. After reviewing the hearing requests, I agree with the executive director that they failed to show how they would be affected by the district's creation in a manner different than the general public. Although Mr. Carlson lives very near the proposed district and discussed many general concerns regarding the proposed MUD, those concerns either would not affect him personally, for example, concerns about the tax rate in the district or the economic feasibility of the project, or were raised generally without describing how they would personally affect him, his mother, or his property. Similarly, the Johnsons and Mr. Schrader both raised general concerns about the district, but don't explain how they will be personally affected. Given this, I would deny all hearing requests. Now I'll pause there, Commissioner Gonzalez, and see how you saw it.
I see it the same way.
Thank you. And since we are recommending the denial of all hearing requests, we must consider the petition for creation of the district on its merits. Turning to that consideration, we have a petition and executive director's technical memo detailing staff's review of the petition. The memo discusses the general information of the proposed district, engineering analysis, summary of costs and bonds, economic analysis, and special considerations for road powers under Texas Water Code section 54.234. From the information in the petition and this memo, it appears to me that the proposed district is feasible, practicable, and would be a benefit to the land within the proposed district, considering the 3 factors and 7 subfactors described in Water Code section 54.021, that the petition meets the other applicable requirements, and that the criteria for additional road powers are satisfied. I would also note that the temporary directors put forth in the petition for creation meet the requisite qualifications, and so I would appoint them as well. So Commissioner Gonzalez, I would grant the petition, approve the road powers, and appoint the 5 temporary directors included in the application and ED's technical memo. How do you see it? I will move that we deny all hearing requests, that we grant the petition for creation of Lund Farm Municipal Utility District, that we find that the petition satisfies all applicable statutory and regulatory requirements, and the district is feasible, practicable, and necessary, and would be a benefit to the land to be included in the district. I move that we approve the district's request for road powers in accordance with Texas Water Code, section 54.234. And finally, we appoint the following 5 people to serve as temporary directors until permanent directors are elected and qualified: Sophia Kidd, Elizabeth Korosik, Reed Olson, Justin Straub, and Ben Wiggins.
Second.
The motion has been made and seconded. All in favor, say aye.
Aye.
Aye. Motion passes. Thank you, Ms. Smith.
So that will take us to our enforcement docket, which are items 4 through 46. And the executive director's staff is here to present these matters.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division. And with me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 4 through 46. The total assessed administrative penalties are $1,012,358, with $170,079 deferred, $176,894 applied towards supplemental environmental projects, and $665,385 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have no questions. We'll hear from OPIC.
Good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. I switched order. Ms. Smith, do we have anyone signed in on these items?
So on items 9 and 11, we have individuals who are signed in and available for questions. And then we have 2 individuals on 2 other items who have asked to address the commission. The first is on item 22. We have Charlie Ross.
Mr. Ross, if you're available, please. Excellent. Come on up. Please introduce yourself. And
Mr. Ross, will you make sure your light is on?
Thank you.
Thanks.
My name is Chuck Ross. I represent Jericho Companies. I just want to make a statement to the commission and not looking for a response. I just want to describe our process that we went through in this particular event. We had an inspector come out to our site. Our office is located within 100 feet of this particular area. And for some reason, they didn't stop in and see us. We found out later about this item. We've agreed to pay it. But when we asked for or requested a hearing when we received the information for the NOV, EOV, we responded timely. We received a response that because it was an EOV, it could only be discussed with the enforcement coordinator. When we spoke with the enforcement coordinator said, well, it's a local issue. It should have been discussed locally. There's nothing they could do. I just want to make you aware of that process that we went through for this. We understand, made the agreed order and have paid it. But I just want to understand we felt kind of out of the whole process and our opportunity to discuss it. Sometimes that works to prevent these items from getting any further. Thank you.
thank you for the comment, Mr. Ross.
Okay, and then for item 35, we have Fabian Haney.
Yes, good morning, Commissioners. My name is Fabian Haney, and I'm the General Manager of Red River Authority of Texas. And I'm only requesting that ours be remanded or sent back to staff. We were recently made aware on a different issue we had from the SCP office that because we are a political subdivision of the state, that we would be allowed to use an alternate SEP, which they called a compliance SEP. And therefore, in our reading of the SEP, we didn't quite understand. We thought we were only able to provide an SEP for some other agency. And as it turns out, we could have provided it for ourselves. So I was just requesting if that item could be sent back to staff so that we could properly apply for a compliance SEP. Thank you.
Thank you, Mr. Haney. I understand your comment. I will ask the executive director to respond to that request. I see a head nod.
Hi, good morning. This is Melissa Cordell of the Enforcement Division. And yes, we would be happy to work with the Red River Authority on utilizing a compliance SCP.
For my part, I think I understand exactly what you've discovered, and I'm glad to hear that the word is getting out about the availability of that that authority. The legislature is now given our agency to give to certain local government entities and political subdivisions in our state. I hope that we find a good argument to build a case for where that benefit could be expanded. But this is a great example of. I'd be in support of that remand today.
I would also, yes.
Thank you. Ms. Smith, any other commenters today?
No one else has signed in.
Commissioner Gonzalez, I have a motion. I would move that we adopt items 4 through 34 and 36 through 46 and to allow and remand item 35 to allow parties to explore further step development.
I second that.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you.
And item 47 is the consideration of the monthly enforcement report. And again, we have the executive director's staff here to present this matter.
Thank you. And I'm so sorry, before we move on into the discussion of that matter, I recognize that we had the comment from Mr. Ross. I did want to make one final point on, if that's appropriate at this point in the meeting, to still touch on that or discuss that. Ms. Smith?
We'll just return to 4 through 46 for
Good.
a moment.
Great. I just wanted to say, for my part, I'm concerned to hear that experience, that comment. I certainly would love to learn more about it, and I appreciate the appropriate boundaries that are placed around how much information the 3 commissioners are able to hear directly from the public. But I have an attorney on my staff, and so I'd invite Mr. Ross to contact my office and provide further details if you're interested in us trying to get a better explanation for you on why that experience was unusual, as I hope that we can give you an explanation for. But I do appreciate you taking the time to come up here today to our meeting and provide your input into that. Thank you. Sorry to ask us to pause on that one. Let's go back to the next item. Thank you.
Okay, back to 47 and the consideration of the monthly enforcement report.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through May. There were 495 effective administrative orders issued, and of those, 96 contained supplemental environmental projects. These orders assessed a total of $8,823,609 with a payable amount of $3,805,593. $4,168,891 are to be paid towards supplemental environmental projects. 11,434 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,459 enforcement action referrals have been received. There are 3,185 pending administrative orders with 1,593 cases that are on the backlog, which again shows a slight decline from last month. 173 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,314 cases are being tracked for compliance. We're available to answer any questions you have.
Thank you. I have no questions, Commissioner.
No, just good to see we're still progressing.
very much share that sentiment. I wanted to note and thank I'm glad to see the continued efforts continue to pay off in slowly but surely working on reducing our backlog. And I'm sensitive to the time, the slow nudging barges metaphor. No action is required on the report,
Did you want to hear from OPIC?
but we will ask OPIC to weigh in on it. Thank you.
Thank you, commissioners. OPIC has no comment on the report except to say that we appreciate receiving it.
And I will also note before we move on that there's no one signed in on this one from the public.
Thank you very much,
You're
Ms. Smith.
welcome.
Well, hearing that, I thank you all again for the report, for your continued efforts. And no further action is necessary, so we'll ask Ms. Smith to call the next item.
So item 48 was continued to the next agenda. So that means that we'll be moving on to item 49, and I'll give everyone a moment to get up here to the table before I call the caption.
Matters.
So item 49 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 290 and Chapter 291 for legislative implementation. And the Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. The proposed, on behalf of the Executive Director, I am Rhea Miller with the Water Supply Division. With me is Ruth Decatur with the Environmental Law Division. The proposed rulemaking would amend 30 TAC Section 291.143 by changing the term for an emergency order appointing a temporary utility manager from a maximum of 180 days to no more than 360 days. The proposed rulemaking also includes a basis for renewing the emergency order under Texas Water Code Section 13.4132. The proposed rulemaking would also amend 30 Tax Section 290.46W and 290.46W6 by adding requirements of notification by a non-industrial public water supply system of an unplanned condition that causes a system outage, issuance of a boil water notice, or other types of drinking water advisories. Additionally, the proposed rulemaking would amend 30 TAC 290.383B II and 30 TAC Chapter 2, Section 290.161 1B II, but by revising the definition of affected utility with the new population of 800,000. Finally, the proposed rulemaking would amend 30 TAC Section 290.3818 or 18 and 290.45J to establish both a connection equivalency value and an alternative recreational vehicle park connection equivalency value used to determine the connection count for recreational vehicle parks that are retail customers of public water systems. A public hearing will be offered on this proposal in Austin on September 12th, 2024. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 290 Public Drinking Water and Chapter 291 Utility Regulations. Staff also respectfully request permission to make non-substantive revisions to comply with the Texas Register requirements. Thank you. We are available to answer any questions.
Thank you. I don't see any questions. Ms. Smith, has anyone signed in on this item?
No one has signed in.
Do we have any comments from OPIC?
Good morning again, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I am Jennifer Jameson on behalf of OPIC. OPIC has reviewed this rulemaking and respectfully recommends publication of the proposed amendments to relevant sections of 30 TAC Chapters 290 and 291 regarding public drinking water and utility regulations. OPIC notes the potential benefit to the public of this rulemaking and that it could result in emergency resources being allocated to the public more readily in the event of an outage. OPIC will continue to follow publication proceedings of this rulemaking as they progress and will remain a resource to the public throughout. Thank you, and we're available for questions.
Thank you. No questions at this time. Well, in my review, I certainly feel that they're an appropriate implementation of the legislative, the statutory implementation from that 88th legislative session. And I think the publication will allow the stakeholders to comment on our staff's proposed implementation of those bills. Commissioner Gonzalez, what are your thoughts?
I agree. Do you want me to make a motion?
Thank you.
I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapters 290 and 291, as recommended by the Executive Director.
I second the motion. Motion has been made and seconded. All in favor, say aye. Aye. Motion passes.
That will take us to items 50 through 52, which are the quadrennial rule reviews for chapters 217, 222, and 324 of the Texas Administrative Code, Title 30. And the Executive Director's staff is here to present these matters.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 50 through 52, the adopted rule reviews of 30 Texas Administrative Code Chapter 217, Design Criteria for Domestic Wastewater Systems, Chapter 222, Subsurface Area Drip Dispersal Systems, and Chapter 324, Used Oil Standards. As required by Texas Government Code Section 2001.039, Executive Director staff conducted rule reviews of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices for the reviews of Chapter 217 and 222 were published in the November 24th, 2023 issue of the Texas Register, and the notice for the review of Chapter 324 was published in the May 3rd, 2024 issue of the Texas Register with 30-day comment periods. No comments were received for these rule reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 217, 222, and 324 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of Chapter 217, 222, and 324. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to the chapters are available to answer any questions.
Thank you. I see no questions. Do we have any comments from OPIC?
OPIC agrees that the reasons for initially adopting the Chapter 217, 222, and 324 rules continue to exist, and we support readoption of the rules in these chapters.
Thank you. Smith, do we have any comments?
No one has signed in.
A question for OPIC. When y'all do your review to see whether you agree or not, do you look at whether the rule's functioning well or just whether it needs to continue?
We do a complete review, Commissioner. We pay particular attention to whether any public comments were received, whether any rules were found to be obsolete, but also the the take on whether the rules are still needed.
Okay, thank you.
Sure.
Well, for my part, I appreciate staff's work on the rule reviews. And in my view, each of these chapters contain rules that are still very much used here at the agency. So I would be in favor of proceeding with the adoption of the rule reviews and readoption of the rules in these chapters. Commissioner Gonzalez?
Yes, I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code chapters 217, 222, and 324 without amendment as recommended by the executive director.
I second the motion. All those in favor?
Aye.
Aye. The motion passes.
So items 53 through 56 are for closed session. The commission will not be meeting in closed session today.
Thank you all for coming. It is 10:18 a.m. and the commission stands adjourned.